Yeah, I forgot to share my screen before I went live. Hey guys, it's Kathy. I hope you're doing well. Yeah, I'm almost an hour late. Whew. I worked a double at a brewery on Father's Day. I worked a double yesterday. And then after work today, it was my daughter's birthday party at McDonald's. Birthday party at McDonald's for my daughter today. But before you get too excited, let me just tell you, she turned 24. She was a 24-year-old. And she was very excited. And Salty B, hello, your icon makes me literally want to go to the beach right now. Oh, I hear there's a really good beach in Australia that Carolyn will take me to. And then I can pretend to drown. And then the lifeguards can save me. Yeah, my adult child had a birthday party at McDonald's, and it was so freaking cheap. It was so cheap. I couldn't believe it. Everybody got food. But we played games. We did. We played games, and the McDonald's workers were playing games with us for her birthday. And now she's gone, spending the night at my other daughter's house, which is lovely. Because now that's why I fell asleep. My kids left. They went to my other daughter's house. Hi, Lisi. Yeah, there's no beer, but listen. It was one of those days where when I got off work, I tried to drink, my shifty, get beers after work. And I couldn't. I was too tired. I just was too tired to lift a glass. So if I would have had a beer at McDonald's, which we should all have beer at McDonald's, by the way, but if I would have, I would have passed out. I would have been so sleepy. And then my kids left and my eyes just went, and I fell asleep, and now we're late. But it's okay, because you can't fire me. Nobody can fire me. Wow, YouTube can definitely fire me. Definitely. Speaking of, how much longer? I don't know. All right, hold on. I'll find out. It's only a couple days. Like 15 days. 15 days, 22 hours, 45 minutes, and 34 seconds. Until I get hired by YouTube again. Absolutely, Darkest. We definitely have content. We have content about, it's Father's Day. It was Father's Day, so we're going to do some car repair court. Guy just wants to get his car redid. That sounds, it's a classic car. He wants to get it fixed up. Let's just jump into it. Yes, you can go to McDonald's anytime you want, Rebecca. You are an adult. You can go eat cake right now. You can go to McDonald's right now. They might be closed, or they might have breakfast. McDonald's breakfast, guys. Oh, yum. That's when I can press the button. Yes. And then other people I heard it'll take 2 days. I'm telling you guys, for me, it'll probably take 2 months, because that's just how I get maximum punished for stuff. I'm used to it. It's just the way life is for me. McRib, no. I'm going to go with no on this. Nope. What do you guys think about the McRib? I know everybody loves them, but no, can't do it. I guess, should we do a poll? Should we do a poll before the video even starts? Don't start talking, you be quiet. I'm going to end the poll as soon as I get one sure. I mean, one hell nah. Hell no, I'm not eating that. Yes. We should have a court vibes party at McDonald's and bring beer. Oh, yes. I cannot bring the beer because I'll drink it before I get there. We're doing a poll for all you people watching on the McRib. Yes or no? And there's definitely a hell nah. No. We'll do it later because there's not too many people in yet. We're going to do this poll again. Yeah, the shores are coming up to 31%. The hell no's at 69%. Yeah, that's why Sarah nailed it. The McRib is even more suspicious than the other meat at McDonald's. Yeah, it really is. It really, really, really is. Fozzie, I didn't see if you were pro McRib or against McRib. We know exactly what it's made of. What is it made of, Kelly? All right, we're only going to one court today. And it's in Georgia. And it's made of people. Oh, gosh. Solvent green, is it? Solvent green? Donald, what is it? Solvent? Not solvent green. I'm missing a word. I need that word. What is that word, people? Solvent green, solvent green, solvent green. Where's Donald? Is Donald here? Soylent green. Thank you, Fozzie. Yes, Soylent green. Yes. That was a good book. It was an okay movie. Let's get started with this. We got to press play. I didn't exactly edit, so I'm going to have to just pop forward 6 minutes, unless you want to see an old lady get evicted.
Other business that is shorter.
All right. Wow, look at that.
You knew. This is why.
All right, I didn't go far enough. I thought I hit it perfectly.
Evidence that do generally have to be free in my head. I'm gonna stand with.
Yes, sir.
Perfect. All right.
Middle age homework.
All right, so we got a guy who's a lawyer, and then we got a guy who's pro se. What more do I have to say?
All right, this is Mr. McCann.
Yes,
correct?
yes, sir.
Perfect. All right, so a couple of housekeeping things to start with. First and foremost, this is a full hearing trial before the court. Mr. McCann, are you an attorney or you're sort of?
I represent myself.
Okay, perfect. Mm-hmm. So just so you know, you are still held to the same kind of standard, generally speaking. The purpose of magistrate court is to do substantial justice. I generally, and Mr. Conwell knows this, he's been before me before, I generally will allow things pretty liberally because I will kind of consider things as much as possible. And I kind of know and keep referee in my head as to what is admissible and what's not admissible. But that being said, there are certain rules of evidence that do generally have to be followed. So if you do get an objection from Mr. Conwell, we're going to talk about it, kind of see what we can do, okay? Are you planning on calling any witnesses, or are you planning on being the witness?
I'm going to be the witness.
Okay, perfect. So in a minute, I'm going to swear you in, and then we will go from there. Okay. Do you want to give an opening statement, or do you want to just kind of dive right on into your testimony?
I do. I'll just dive right into the testimony.
Is that okay with you, Mr. Conwell? had an opening.
I generally like to paint a roadmap.
Okay, good.
Maybe I'll go first and he can respond to my.
That'd be fine.
Let's do that.
Is that all right?
And I have some documents for you, Your Honor.
That's fine. We'll get to those in a
Okay.
minute. Once you feel like you need to give those to me during your actual testimony portion,
Okay.
that's when you can give those to me. Okay.
All right.
All right, Mr. Conwell.
Thank you, Your Honor. Your Honor, please, the court, I believe the evidence is going to show today that my client operates a shop here in town where he restores automobiles for his clientele. And prior to these parties meeting, he had been doing that for a number of years here in Dawsonville. And as part of serving his clients, he issues a contract. He has them go over a contract. There's a contract in this case, which is very clear as to what the expectations are of him, as well as what the expectations are of the client. And there's quite a bit of explaining in his contract. The evidence will show that when you're restoring a car, costs and such are difficult to estimate. But that's not really the issue. We don't have an issue here today where costs became exorbitant. What we had is an issue where the parties entered into a contract whereby there was supposed to be a $10,000 deposit paid, and that would be so to cover parts, labor, et cetera. That contract was duly executed and signed by the parties. But I believe the evidence is going to show that the plaintiff in this case, although he signed the contract, I think the evidence will show today that he had no intention of abiding by it. I think what he intended instead of giving a $10,000 deposit as the contract provided, so that my client could perform labor and bill against that deposit and buy parts. I believe that the plaintiff's his understanding of the industry standard, as he quotes it, the evidence is going to show that he's going to make weekly progress payments, which was contrary to the contract. So it very quickly led to a sort of a falling out of these parties in terms of there was a breach of the contract, at which time my client stopped working on the vehicle. His contract provides for storage fees. He sent invoices, which under the statute, it mentions about making sure that someone is on notice of storage fees. The evidence will show that the plaintiff in this case was on notice of storage fees, and that this vehicle sat inside my client's shop, and he only has 2 bays, I believe, 4 bays. So
It was a 3.
that's okay. So losing a bay to a vehicle causes damages. He's not seeking the damages for missed work during that 2-month period. That's what the storage fees are, is a liquidated damage for not having use of the bay, which is in the contract. It's in the invoices. The plaintiff was on notice of that. The car ended up sitting over a year, and with a couple months inside and the better part of a year outside. And so, again, we believe the evidence is going to show that the plaintiff in this case is not entitled to relief as the breaching party, and that instead that this court can go forward on my client's counterclaim for what he's owed on the invoice, which would.
All right. Now I'm just going to tell you, this guy's the plaintiff. This guy's the one suing. You're going to think he's the defendant half the time because of everything that goes on, but no. He's the one that wants money. Yeah. And then this guy's like, okay, you want to sue me? Countersuit. Here comes the countersuit.
would include some repairs and storage fees.
All right, Mr. McCann, very similar to what Mr. Conwell did, just kind of paint me a picture from your side of what you're planning on showing, okay?
Okay. You want me to do it from here or up there?
Whichever is most comfortable for you.
Okay. I can come.
Not yet.
Okay.
During the regular testimony portion.
Okay. So in regards to this situation, I found Redemption's Body Shop on social media around the early part of June. We had some conversations. On June 27th, I had my classic 69 convertible Cutlass delivered to his shop. When we got there, we went over the contract that he's talking about. He wanted a $10,000 deposit up front. I asked him how much did he think that it would cost to do some minor restorations on the car. Obviously the car is as old as I am, 55 years old. So, but the car was in very, very good shape. It had rust in the fenders and it had rust in the quarter panels and it had a little bit of rust in the trunk. And I asked Mr. Collin, I said, on a scale of 1 to 10, what would you rate this car? To 7. So basically what we were going to do is that he started off doing sanding on the car. He sanded the hood. I have pictures of that. He did a great job. He removed the fenders and he cut one quarter panel out and started cutting on the other one and didn't finish it. So in regards to the contract, we signed the contract. I said very specifically, I don't want to give you $10,000 up front because I've restored cars before. And it's been a nightmare giving a large deposit up front and then you don't use all the money and trying to get your money back. So what we agreed on is that he said in his own words, Vincent, this is how it's going to go. What I'll do is I'll invoice you weekly based on the work that I'm doing on the car, and then you pay me via Zelle or whatever the case may be. And that's what we did. So looking at the agreement, the first thing he did was sand the hood, he removed the fenders, and he cut the quarter panel out of the right side of my car, okay? The car, I paid him $1,200. $1,000 was the first payment I made. So then the very next week, same thing. He did some more little work, invoiced me, I paid him again, okay? Third week, same thing. Then he came back and he wanted this large deposit again. I said, no, I don't want to do the deposit. So at that time, then he stopped work on the car. So in the interim, where we were trying to find a middle ground, I had 2 other vehicles that I had him do some minor work on. One was a 2020 Porsche Panamera that had some rock chips on the front. He sprayed it, repainted it. I wasn't 100% satisfied with the job, but he did it. Second was I have an E350 Mercedes that was struck by a piece of wood that came off somebody's car. It was an insurance claim. He fixed that. Work was okay again. All right. So we did that in. So then he came back to me. He said, look, if I can't get my deposit, then I'm not going to be able to do any work on your car. Inside his bay with all the parts pulled off it pretty much for about a month. Okay. Then he told me he was going to move the car outside. He moved the car outside. When he moved the car outside, because it is a classic car, I came up and put a car cover over the car and strapped it down. Everything stopped at that point right there. Then, since he couldn't get the $10,000 deposit, he started trying to charge me $35 to $100 a day in storage, per day in storage, as the car sat outside. Okay. So 8 months passes. There's no movement.
Okay. If someone told me I was going to get charged 30 some bucks a day, how does 8 months pass? 8 months pass. And he's like, wait, I'm not paying this bill. This is stupid. 8 months passed and he's like, yeah, maybe I should try to take care of this.
I contact him about the car and I ask him about the condition of the car because it's been outside, whatever. oh, the car cover blew off. And I said, well, when did you notice the car cover blew off? Oh, some time ago. And I said, really? So I go up to inspect my car. Your Honor, my car is completely rusted out. The quarter panel where he cut it out completely, I have pictures of it. The hood, all the work that he did was rusted out because it sat in the weather for 8 months. That's why I filed this claim, because when I brought the car to him, it was in one condition. Now the car is in a completely different condition. Now I have the same identical car at another body shop in Dalton, Georgia, that is completely restored. I've had no problems with this person. This person is waiting on this car. I sent him pictures of.
Not exactly. So in the shop, there's 4 bays or 3 bays. I couldn't see his fingers at the beginning. And the car took up one of those bays for the first month or two. It was inside the shop. He did some work on it. This guy gave him some payments for the work, but in the contract, it says you got to put a $10,000 deposit down. That's because this guy uses that money to go buy the parts and everything like that. Instead of him buying the parts out of his pocket and then invoicing this guy, he wants the deposit up front. That's completely fine in my book. I mean, it makes sense. Well, once this guy stopped giving him money and didn't give him that deposit, he took the car out of his bay and took it outside and left it outside because he needs his bay to work. That's where he does work on the cars and makes money. So there's no bay outside. It's just parking lot. I don't know what he thinks.
The car, he said it's going to cost you $12,000 to get all of this rust off this car. As a matter of fact, we're going to have to put all new parts on this car, and the parts that I can't replace, we're going to have to sand. So I'm losing money on this deal by dealing with him. So that was June 27, 2022 that I dropped the car off. I have not been able to get the car back in 2 years because he sent me an invoice for $33,000 in storage fees at $35 to $100 a day. And Georgia law doesn't even allow him to charge that. And then the last piece is, in the agreement and contract that we signed, there was no stipulation about, it mentioned storage fees, but it did not mention anything about the amount.
Trying to think. We kind of went into some testimony there on some things. So, Mr. Conwell, obviously you heard everything. Are you okay with me swearing him in retroactively?
Yes, Your Honor.
Everything he said so far?
Absolutely.
And then you still have your chance to cross-examine.
Absolutely.
So if you'll just raise your hand for me, please. Do you swear and affirm the testimony that you have given and will continue to give in this matter to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, perfect. So that takes care of everything before. And so I'm going to ask the question again. Everything that you've said up to this point has been the truth from your personal knowledge, correct?
Yes, Your Honor.
Okay, perfect. All right. So now you have a stack of papers and some things. Go ahead and go through some of those. What I ask you do is actually work with Mr. Conwell. You have to kind of show him what you're going to show.
He has copies.
He has copies.
Yes.
You're good.
As long as everything is as it was at the day of our mediation, I have exactly.
The only thing that's been added, Your Honor, is my payment history. That was missing the last time we were here. That was it.
Oh, I would like to see that.
Yes. If you'll just show that one thing for him, please.
Okay. Thanks.
Yes. Invoice. And here's my payments.
All right. Thank you. And I have no objection to,
To anything so far?
no, sir.
This guy's lucky being pro se. This judge is so laid back and forgiving. And the lawyer is too. The lawyer could have objected to that whole opening statement.
This is the only copy of these?
That is the last invoice I received with all the payments on it. They should match.
All right, but these are the only copies of these, in other words. We'll work from these two.
Yes.
Okay, if you want to give these to the court, then I'll.
Yeah, they have copies.
Oh, the court already has copies? Oh, okay, perfect, thank you.
Okay, yes, the first 2 pages.
Yes.
Excellent.
And no objection to these 2 pages?
No objection, Your Honor.
And there was no objection to the other documents, correct?
No, sir.
So what that means is I'm gonna take those into evidence. They're in the case. Now, we still have to prove everything related to everything, okay? So go ahead and kind of walk me through what we have here. if you don't
Okay.
mind.
So, Your Honor, the first page that you see, this page here, the summary page, basically has 3 points that I want to prove today. Okay. And I've already kind of gone into a little bit of that. So that's good. Just read material for you. The second thing is the contract, the actual contract itself here. Okay. Yes.
Yours is sort of a picture of it.
Okay.
This, if you want to just go give that to the court. It was attached to my pleadings as well, but.
Okay. So the contract is something that the defendant is using as leverage in this case to say that there was a mention of storage fees. Yes, there is a mention of storage fees, but it's not spelled out. And as you know, if it's not in the contract, it doesn't exist. That's the bottom line. So you cannot use the contract, and I deal with contract law every day in my day-to-day job. And I tell my people all the time, if it's not spelled out in the contract, it doesn't exist. You don't have a case. So the contract, if you read it, is pretty vague. It mentions the storage fees. I mean, it mentions the storage fees and it mentions the $10,000 deposit. But Redemption's Body Shop elected to accept weekly payments in lieu of that deposit. And that's what Mr. Cullen said to me. Well, Vincent, this is how it's going to go. I'm going to invoice you weekly. And as you can see, he invoiced me weekly and I paid him per the work he did per week. And that's what we operated on until we could not go any further.
Okay.
I also have pictures here that, and I'll show you something. This is the hood that he sanded on my vehicle. Okay. This is the hood of my vehicle after sitting in the weather for 8 months. Same hood.
Okay.
Okay. The entire car rusted out. It's a convertible. It has no doors on it. He took the doors off it. He never replaced the doors. He sanded the doors. He never put them back on the car. So when the being exposed to a weather, I think anybody in this courtroom can attest, you got no doors on the car and you got a convertible car, the whole inside of the car is going to rust out. And that's exactly what happened. So here's a picture of my car. The quarter panel he cut out, it rusted out. The inside of the car rusted out. My hood rusted out. Pretty much the whole car is toast. And the gentleman that's waiting to pick up the car that's doing the restoration on my other 69 Cutlass just quoted me a price based on what he sees. He hasn't physically seen the car yet. So we don't even know if the car can be saved or not. So that was negligent. That's the negligent part that I'm proving in my claim here, is that if the car cover blew off the car and you pull up and you see the car doesn't have a car cover on it, and I covered it and I strapped the car cover down, common sense would say contact the client and tell him your car cover's blown off your car. Not wait 8 months later. The car is still sitting on his property now, recovered, because I went back up and put another car cover on it. And that was maybe 3 months ago. But I have not been able to get my car back because of those exorbitant storage charges, $33,000, I believe, that are not even legal in the state of Georgia to charge. So I rest, Your Honor.
All right. So do me a favor, if you will, come and sit over here for me.
Okay.
Mr. Conwall.
Thank you, Your Honor.
All right, lawyer, go get him. Go get him.
Good morning.
Morning.
The timeline document that you had there, may I refer to that? I'll be asking. Okay, according to your timeline, Monday, June 27th of 2022, your car arrived at Redemption's Custom Paint and Body. And it had previously sat over a year. Is that correct?
That is correct. It was, with one exception.
Okay, tell me.
Okay, so, Your Honor, the car was at another body shop before it arrived at his body shop, but it was inside. And the gentleman, it was in South Georgia at a person's body shop that I know. And the gentleman just didn't have time to work on it. He took it in, he planned on restoring it. He's very busy, but it was parked inside for a year. And once we determined that he was not going to be able to get to it, that's when I started looking for another body shop, found him online, and then had the car shipped up to his body shop.
Okay. And I'm just going through the timeline, and I'm approach. Please take a look at what the previously marked Exhibit A as the contract. And what I'm going to be asking you is that your signature and your information on that document?
Yes.
Okay. Now, according to this document, you would agree with me that, may I stand by the witness for just a moment? A $10,000 deposit is required at the time of commencement of the restoration, correct? You mentioned during your direct that you deal with contracts every day if it's not in the contract, et cetera. So a plain reading of that is $10,000 is required at the time restoration begins, right? All right. And you mentioned during your direct that the two of you talked and decided that you were going to vary from that. That was your testimony, right?
Correct.
All right. Now, as part of the information that you gave the court here today, you had some text messages between yourself and Mr. Callanan, correct?
Correct.
I'm going to direct your attention to conversation that the two of you had. Or that you sent on July 27th. This would be a full month after work commenced on your car, correct? All right, take a look at that. You remember sending that to my client on July 27th?
Yes.
All right. And Your Honor, what I'm showing the witness and the plaintiff is is this July 27th. The top says me. That's now been authenticated by the plaintiff. Consists of 3 pages or so. I'm just going to read from this.
Okay.
You say, Matt, I initially scoffed at your request because it's not industry standard. As time passed, I learned more about your operation, and it made more sense for you to complete certain work, show progress, and be paid. So that differs. This indicates that the decision to pay on these progress payments was unilateral. That's something that you decided to do, and Mr. Callanan was asking you repeatedly for your deposit, correct?
No.
In fact, okay, you're saying you deny that.
So as I mentioned in my testimony,
Mhm.
Mr. Callan said to me verbally, Vincent, this is how it's going to be when our first initial meeting. He said to me, Vincent, this is the way it's going to be. I will invoice you weekly based on the work that I'm doing, and I expect immediate payment. And I said, okay. And that's what we did. That's what the payment history shows. That's what everything shows. In regards to the deposit, when I signed that contract at that time, he had, as the owner of the shop, he had every right to say, I cannot begin work until I collect my deposit, that $10,000 deposit. He did not do that. He's the person that told me that he would invoice me weekly as an alternative, and I would pay him. And that's what I did.
Yeah. You've submitted an invoice, the invoice that you were given here. May I approach? Yes. And showing the payments. You see the invoice that you were given, and there's some fine print there on the bottom of it as well. On the invoice actually contains the $10,000 deposit, correct? In fact, and also in the materials that you provided, you communicated with his wife and said, hey, wait a minute, this invoice I got was $14,000. Remember that conversation that you had?
Mm-hmm.
Right. So the first invoice that you got, despite your assertion that the two of you agreed to do something outside the contract said 10,000. The first invoice said 10,000, and you contacted his wife and said, wait, I'm already at 14,000. And you were reminded it's because there's the $10,000 deposit that you have to pay, to which you debated that with her. Isn't that correct?
No.
Well,
Because as I've stated several times, he put that deposit into the invoice, but he did not enforce it at any time.
okay.
He could continue to collect weekly payments, whatever the amount was, whether it was $1,200 or $1,000 worth of labor or whatever it is that he did, he invoiced me for it and I paid him promptly for it. He never enforced the $10,000. What happened is that he left the $10,000 in the invoice, but then he started charging me storage fees. So you see the amount, when you look at the overall invoice here, if you look at the overall invoice here, the bottom says balance due $33,749.96, which includes the $10,000 right here on this line right here. And it also includes storage fees.
Yes.
That he cannot charge me because it's not outlined in the contract.
Well, in fact, as you'll see at the bottom of this invoice, it very clearly states what the storage fees are. You would agree with me, correct?
No, it doesn't. It
All right.
doesn't.
Do you have your reading glasses on? And I have
And I will read it to the court. Not responsible for pre-existing damage, only the area that redemption was paid to repair. On restorations, we require $10,000 deposit or 50% deposit on regular paint or collision work required so we can get your materials. If quoting price over pictures, the price may change if there are misleading or whatever. This doesn't have anything. This just continues to keep repeating the $10,000 deposit that he wanted, that we both decided that we would not do.
also in your materials is a close-up version of that invoice, although this is where you had circled your payments. Do you see the language? Do you mind reading that?
It's the same language that I just read on this one. And counselor, again, going back to contract law 101, if it is not stated in the contract, you cannot enforce it. And the only thing that's stated in the contract is a $10,000 deposit that we both, and he said to me, Vincent, this is how it's going to go.
Counselor, contract law 101 is I signed this contract saying I was going to do all this stuff, but he didn't enforce it. So then when he enforced it, it doesn't count.
I will invoice you weekly and you will pay me for the work I've been done. At any time, counselor, he could have said to me, I'm commencing work until I receive the deposit, the $10,000 deposit.
Respectfully, I'm going to have to object. That's not responsive to my question. My question to you was, do you mind please reading at the bottom of the invoice what it says about storage fees? Clearly right here, a storage fee of $100 inside storage per day is applied when the car is not being worked on because of the customer, and 35 outside storage. Do you see that?
Yes, but I did not sign and agree to it.
Okay, but you signed a contract and agreed to that you would be charged storage fees, and beyond that, also in the material that you provided, Mr. Callanan also sent you a picture of the signage that's all over his shop that indicates what the storage fees are, right? That's in the material.
But it's not in the contract.
Right. And
I can put a sign up on this wall here and enforce it after the fact, but it won't hold up in a court of law under contract law.
right. Is that
That is, but it's not,
driver? That's what I'm saying.
but it's not enforceable. It has to be in the contract and it has to be agreed and signed by both parties. That's where the issue is.
Well, it seems the issue is that Callahan to be bound by the terms of the contract, but you don't want to be bound by the terms of the contract, which was for you to pay the initial $10,000 retainer, right?
No. Mr. Callan, again, said to me, Mr. McCann, Vincent, this is the way it's going to be. When he made that statement, he went against his own contract.
Okay. Isn't it true that as Mr. Callahan began work on your car, he quoted you, he did research on what the parts were going to cost, and he sent you that information, to which you said, that's too expensive. I'm going to find the parts myself cheaper and I'll get the parts. Even though the contract stated that you would be charged for parts and labor. You stopped him from working on this car because you were going to find cheaper parts. Isn't that true?
That part is correct.
Okay. And so the car sat in his shop from August through September inside, after the doors had already been cut off and everything, awaiting parts that you were going to buy that you didn't get.
No, that did not happen. The car sat inside the shop for a month. The parts the 469 Cutlass are extremely hard to get. This is right after COVID, and we were having all kinds of supply chain issues. So I reached out to a catalog department that specializes in parts for that car. And my MBA is in supply chain, and I understand supply chain. And when I contacted them, they said those parts are going to be on back order because of COVID and all the supply chain issues that were going on. I went and told Mr. Callan at that time what was happening. Mr. Callan said, okay, no problem, or whatever. And that was it. He made the decision to move the car outside after a certain amount of time. He made that decision. I didn't make that decision. And I had no control over supply chain issues. And again, as I've stated several times in this court, the bottom line is he breached the agreement. He breached his own agreement when he decided to invoice me weekly for the work that was performed.
Isn't that stated in the contract?
The contract is not enforceable if it's not in the contract.
The contract states, invoices reflecting work performed and the amount of your deposit will be used and sent monthly or on or about the first of the month. A photo record of work performed for the month will also be provided. These digital photos will be emailed or posted on the Facebook page.
And he did not enforce his contract.
Okay, that's your opinion.
That's fact.
Well, the fact is, you didn't pay the invoice when you were invoiced, right?
I did.
You didn't pay the full amount. In fact, you rejected through.
There, I can go back in here. I can find a text message where he said you were caught up in your current. Would you like me to present that? Your Honor.
Do you have, well, my question is this. You were given the invoice. I'm going to show you what you said.
And I'm just going to remind everybody again, real quick. He's the plaintiff. He brought the lawsuit. He's the one that wants money.
Here are the 3 payments that I made.
Yes,
Per his
that's
There
in,
you go.
that's in evidence.
Okay.
All right, here it is. Aaron, is that his wife's name?
Yes.
That you're not on the stand yet. Did you email or text message Aaron?
So
Yes or no, and then you can explain.
I did text Aaron.
Okay.
Okay. And let me explain to the court.
Sure.
Things got after, as I said, I had 2 other cars that he did repairs on, and the work was shabby at best. Okay. The relationship between me and Mr. Cullen became so strained that his wife stepped in to save the relationship. So she told me, communicate with me versus talking with him, because every time I tried to talk with him via text, it would go all over the place. So she and I started talking. Even at one point, she came and picked me up and dropped me off to pick up my car and that kind of stuff, whatever. So we started talking amongst ourselves between her and I. And I wanted the court to understand that's how she came into the play.
In fact, so here's the communication. This was in your material. It says, also, this is my exchange with Aaron. Aaron, can you explain why I received an invoice for $10,000 and now storage fees?
Not only that, he brought 2 other cars to him to get fixed too. Then he has another car at another shop somewhere that's identical and whatever.
You see that? Matt, you mentioned the original price of $10,000 is going to be too much. He can definitely make it work for less. He is thinking $5,000 will be enough. Your invoice is priced at $14,407.
Okay.
So you received that invoice, and I'm moving to another. Matt, on October 19th, you sent a text that you were charging me $3,450 for storage fees, which are more than it will cost me in a monthly storage unit. Today, 11 days later, the bill has increased. Matt, I can't get the parts for the car due to supply chain. You acknowledge that?
Yes. That's what I just stated to the court.
Okay, so now I'm going to tie that all together, and you feel free to disagree with me if you'd like. Car comes in June. He sands it down. He tells you he needs parts, right?
No.
He didn't tell you he needed parts for the car.
I started doing prep work on the car.
Yes.
So he sanded the hood. The hood was salvageable. He removed the front fenders from the car, both right and left.
Mm-hmm.
And he cut the left quarter panel out of the car.
You're fine,
When he
Clarice.
cut the
You're
left
fine.
quarter
You can
panel
stay.
out of the car. That's when he requested parts, because we need the obvious quarter panels.
And when was that? So the court knows a date.
I don't know the exact date when he did it. It was in June. It was probably the first part of July, to be honest.
In
Right.
fact, it's on your timeline.
Okay. So when he cut the quarter panel that's when he started requesting parts.
Yes.
I reached out to a parts depot that I've dealt with in the past. I've owned probably 12 classic cars.
Mm-hmm.
And this was right after COVID. This was 2 years after COVID, and supply chain was screwed up.
Okay.
So as I mentioned, it's very hard to get parts for a 69 Cutlass convertible.
Yes, sir.
So there's only a couple sources that you can go through to get parts. When I contacted those 3 sources, all 3 of them were having supply chain issues getting parts. And that's what delayed the parts coming in.
if I may, Mr. Callanan told you he had a supplier that was going to send him the parts so that he can continue to work. And the issue wasn't the supply chain. The issue was you thought that the price he was paying for the parts was too high.
No, what he said to me is that I can probably get the parts. He didn't go into detail about it.
All right. Nevertheless, the car sat, right? And you had been in that shop multiple times with the Porsche, with the Mercedes, and also with the Cutlass.
And with his wife.
You've seen all the signs about storage fees. You've seen it on your invoices. It's in the contract, and you guys have texted. We've demonstrated that to the court numerous times.
No, that's not what happened. What happened is that when we were going back and forth about the storage fees, he sent me that picture. I never saw that picture personally. And if you look at that picture very closely, he has his fingers over, if you can show it to the court, he has his fingers purposely covering the amount of storage fees. Can you show that to the court?
Sure. But that wasn't responsive to my question. But since we're doing this informally, I'll let you continue to talk there. But what is, may I approach the court? Sorry.
You don't have to ask anymore.
This shows inside storage and outside storage, and it shows 135. And he says his thumb is covering the per. So it says per day, but he's using his thumb to point to it. He didn't realize he was covering the per. But that same information that's on the signage in the shop is also on your invoice, correct?
No.
We've already established that. The zoomed in and the material you provided shows it.
There's no amount that is on the contract that I signed in regards to storage.
Okay.
The only mention in that contract is the $10,000. There is no storage fees applied in the contract that Your Honor has right there in front of him.
Okay, so going back to in June, Mr. Callanan tells you we're ready for parts. He can get the parts, and he gives you an estimate of what those parts are going to be, and you say you want to get the parts yourself.
That is not what happened. That is not what happened.
As
I can state again to the court, when we had the conversation about parts, I decided that I could get the parts cheaper.
Yes.
That part is correct.
Okay.
So I reached out to my sources, and that's when we found out about the supply chain issues. Mr. Cullen and I never had a discussion about the amount of the parts or anything like that. He just said, I need to get quarters. I need to start on this, whatever. And that was it.
All right. And then you were unable to get the parts all the way through October, which means the car was sitting.
So if you just walked in, real quick summary. This guy right here is the plaintiff. He is suing this guy. He has no lawyer. This guy does have a lawyer. So the plaintiff had an old Cutlass that he wanted restored. So he took it to this guy's shop. This guy signed a contract with him, and he said, you're going to have to put a $10,000 deposit down so I can work on it, go get parts, things like that. So this guy brought his car over, put it in one of the bays of his shop, but never put that $10,000 deposit down. So week one came, and this guy did some work on it anyway, and the plaintiff paid him $1,000. Week two, this guy did some more work. The plaintiff paid him $1,000. This guy said, look, I need that deposit down. I need that deposit down to buy the parts to work on your car. And this guy said, no, I don't want to put a $10,000 deposit down. I don't like doing that. This guy said, okay, then I'm not doing any work on your car. And he let it sit in the bay inside his shop for a month or so. And this guy still didn't pay anything. So then he took the car outside, and then he charged him per day, 30 some bucks per day in storage fees. 8 months later, this guy calls and asks about his car, and he owes a ton of money now. But he's the plaintiff. He's suing.
In a bay,
No.
just sitting.
No, it wasn't. Car sat in his shop for a month. At that time, after he contacted me via text, and it's in the text messages,
Mm-hmm.
and he said, I need my bay because I need to get other cars in here to work on.
Yes, he did.
And I said, okay, I agreed that he can move the car outside.
Yes.
At that time, the next day, I came up with a car cover, put the car cover on the car because he moved it right out of the shop and moved it on the side. I put a car cover on it. I strapped the car cover down. And that's why I was alarmed some months later that he told me the car cover had blown off. And to this day, I'm still scratching my head because I tied that car cover down pretty well. But he told me 8 months later that the car cover had blown off and the car was rusted out.
On purpose?
And that is our case here, basically, is between that and the storage fees. Because now I have a car that was worth a considerable amount of money, and now it's rusted out, and I don't know if it can be repaired. So the $4,000 or whatever I paid him pales in comparison to what it's going to cost me to get it now completely restored when it had minimal rust on it, or it's got to be scrapped.
Okay. Now, I understand that you are a layperson in these things, but I'm going to ask a yes or no question, and I want you to answer yes or no, and then you can explain. Would you agree with me that from end of June or early July until after October, that car was sitting because you couldn't get the parts?
No, that is not why it was sitting. The car was sitting because he and I couldn't come into an agreement to continue our business relationship. It was two ways. It was not one way. Because I could have easily came and picked the car up and took it home or took it wherever I wanted to take it.
Very good.
But hold on. Reason why the car, when he could not get his $10,000 deposit, he decided to shift and charge me storage fees. What he said to me in
You got this. You got this. It'll be over soon.
his own words is, I have people to pay here. I have a shop to run. Then at one point, he even tried to negotiate to get the car away from me. Well, if you don't pay storage fees, you can just let me have the car.
Okay. Back to what I was asking you before. You just said, again, on cross, I could have taken the car whenever I wanted to, but you left it sitting outside. And again, now whether you said you saw the sign inside about the storage fees, your contract puts you on notice that storage fees would be charged. The invoices put you on notice you'd be charged storage fees, both inside or out. You had verbal conversations about storage fees and text conversations about storage fees. And you just said, when we moved the car outside, I could have taken it home, but I chose to leave it right there.
No, I didn't say I chose to leave it right there. I never said that. What I said to you was, when the car went outside, he immediately started charging exorbitant storage fees. I can't just go up there and remove my car.
Sir, you said, I could have just removed my car right at that point. That's what you said.
I said that, but guess what?
I don't know.
Because what I'm saying in regards to what you just stated is that when he moved that vehicle outside, he could have said to me, come pick your car up. That never happened. What he did instead is move it outside and start charging me exorbitant storage fees right off the rip. The communications that you presented yourself, when I was questioning his wife and questioning where these fees were coming from, that's what the holdup was on the car. That's why I couldn't remove the car, is because I was getting $4,000 bills, $6,000 bills, now a $33,000 bill. If I go up there and just take the car after he stayed in that, I could find myself in jail. So that's why the car has been sitting, is because I can't go remove this car until Your Honor makes a judgment in this case, whatever way, then legally I can remove the car. So the car has been tied up because of the exorbitant storage fees that by Georgia law, he can't even charge. The law is only $1 a day. That's the law. And I provided that to the court. You can't just arbitrarily make up, you're going to charge $35 to $100 a day on storage fees that's sitting out in a parking lot. Legally, you can't do that.
Okay. You see in the contract, it states here on page 2 of the contract, right? Parts and material will be billed at retail, right? Hourly rate is 95 per man hour, 94 per man hour, correct? Insurance on the vehicle while in possession of redemption customs is the responsibility of the owner. And also, it goes on to page 3. It talks about damages that result to any loss that's suffered when you put the car outside, when the car was going outside. You said in your opening that he did that unilaterally, but you said when you were testifying that he told you he was going to have to move it out of the bay. You came up when he moved it out of the bay and you covered it. So you knew it was going outside. But you're whether or not your testimony is conflicting is for the judge to decide. But it says, in the event the customer initiates a hold on work, a storage fee will be assessed until a new deposit is received. We cannot guarantee your vehicle will be stored inside the shop for classic cars while in progress and not for storage. This contract is replete with notice about storage fees.
It says it right there in the contract.
So if I can state something, I'm in the IT business and we deal with contracts all day long.
Yes.
And
Obviously
if there is
not.
a change between my company and the third party, we do what's called a change request. The equivalent in this case would be a new contract that would state, you're moving your vehicle outside. This will be the fee, the storage fee. Do you agree to it? Yes
It's
or no?
in the
If I agree
contract
to it, I sign
already.
it. If I don't agree
You
to it, then
signed
I
it.
don't sign it. That's what's missing here.
No, it's not missing.
You cannot arbitrarily charge somebody whatever you want to charge them for storage. They don't sign off on it and then try to enforce it. You can't legally do that.
No, David, dear, he did not.
Just hitting some check boxes here. Again, when you were presented with the invoice, you didn't pay it.
I did pay it.
The $14,000 invoice.
No, because that's storage fees.
Well, you've already mentioned to the court that part of the $14,000 invoice was the $10,000 deposit that you said that.
I don't know why, Donald, but I feel personally attacked by that statement.
He never intended to enforce. But you didn't pay that, right?
No.
Right. Okay. In your IT business, when your company is presented, or when you present an invoice to a customer and they don't pay it, what happens?
Well, I've never had that happen. But what we do is we invoice based on the same way I did with Mr. Cullen. We perform the work, we invoice the client has 90 days to pay it. That's the way it goes. But we have what's called a scope of work, which we've been talking about. We also have contract language in there that covers everything. So if I want to charge time.
I don't want you to get too far off the field. I said is what happens when they don't pay the invoice. That's all I asked you.
Yeah, well, I paid the invoice.
You've already testified that the $14,000 invoice, which included the $10,000 deposit, was not paid. In fact, your total payments to date
I paid the invoices that he sent me. These 3. This is what I paid, minus storage fees. And I paid those as soon as he sent me the invoice. And that was on a weekly basis.
All right. I don't have any further questions for this witness.
All right, Mr. McCann. Before you sit down, because I don't want you to have to move too many times. You're still giving live testimony. This time, I would normally ask if there's any redirect, meaning if there any more direct testimony that you want to give. Before you do that, just so that we're all on the same page, anytime that you give direct, it then opens the door for him to do more cross. Okay, so your testimony is really controlled by you as to whether or not you continue to give testimony or not. Okay, so is there anything else that you want to give in terms of testimony?
No, Your Honor. And I rested when I was at the stand.
Perfect. All right, then you may return to your seat.
Thank you.
That nailed it right there.
Yes, Mr. Callahan.
You understand.
Mr. Callahan, will you please go to the witness box and remain standing, and I'll administer the oath with the permission of the court.
Yes.
You get to go have a seat right over there. Okay. But actually just remain standing when you get over there. I'm going to administer the oath, okay? Please raise your right hand. Do you solemnly swear or affirm the testimony you'll give the court in this matter today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, please have a seat and introduce yourself to the court.
Well, my name is Matt Kellenian, and I'm the owner. My wife and I are the owners for Jim's Custom Paint Body,
Okay. And where are you located, sir?
Dawsonville, Georgia.
All right. How long have you been restoring cars, working on cars, sir?
32 years.
All right. And as part of your standard operating procedure, do you have a client execute a contract for your services?
Yes.
And is
all this stuff don't happen. Pardon, I've been there, done that.
all right. And in this case, we've established that you and the plaintiff in this case executed Exhibit A, which was your contract. And if I may stand over by the,
We got Melissa, we got Victoria. Where's Ramona? We can have court in here. Who wants to be the judge? Victoria will call the cases. Melissa will tell you, what's going on, everything that's going on. And then who wants to be the judge? Who would be the best judge? We should take a vote. Not at who wants to be the best judge at court vibes. Steve is going to send everybody down to jail. So you know what, Steve? You're the judge. Dave's the victim. Yeah, I know. Well, okay. We should do that someday. We're going to have a full court hearing because we all know law. We know law better than the lawyers know law. We make fun of them all the time. Okay, we don't know law. We only think we know law.
witness. This is the contract that you executed
Yes.
with the plaintiff in this case, correct?
Yes.
All right. Now, it was asserted by the plaintiff that even though this contract says a $10,000 deposit is required, that you actually didn't require that. Is that true?
No.
All right. Please, if you don't mind, walk the court through the timeline of your dealings with Mr. McCann and the 69 Cutlass.
So everything started out fine. He brought the car to me to get restored.
That sounds
And
fun.
then I was working at, like we talked about, I started stripping things down, sending parts off to say, oh, this messed up, we need this. And
Let me ask you this. According to Mr. McCann,
Michael,
on
yes.
Monday, June 22nd, 2022, his car, his Cutlass convertible, arrived at your shop.
correct,
And then on the 29th, you began disassembling the car. Is that correct?
correct.
All right.
Sounds right.
And Thursday, June 30th, you sent a text where you were going to begin stripping down the hood and applying epoxy on it so that it would be ready. Is that true?
Correct.
And then sanding was completed. He says epoxy was never added.
Right.
I think I should be the prosecutor, guys, because hear me out. Everybody keeps saying to me, please stop talking. Please stop talking. And I'm ignored. So I think I should be the prosecutor.
Is that true?
Yes.
All right. Picture of hood fully sanded. Why was the epoxy never added?
Because you never paid.
He didn't pay. So
I
by
couldn't buy materials. That's why it required the deposit.
all right. So by Thursday, June 30th, 2022, he hadn't paid anything toward his deposit, correct?
No, sir.
In fact, according to his exhibit, what was the date he first paid you anything toward the work?
And
See, the very first payment?
July 1st.
Objection, leaving.
$1,175.96.
Okay. And then the next payment was July 8th.
July 8th, yeah.
And then the last payment, July 29th.
Yes.
Correct?
Yes.
All right. And so that would make sense that you didn't apply the epoxy on the 30th because you weren't getting paid. Correct?
Right.
All right. And so at any time, did you tell Mr. McCann, oh, don't worry about the $10,000 deposit. Just pay me weekly?
No.
All right. Is that something Mr. McCann did
He
unilaterally?
tried to micromanage how I run my business and tell me how it should be.
All right. Now, next, he says, these invoices, when did he request invoices on July 1st and July 8th when he paid these?
No, I just send them weekly.
You said,
Whenever it changes.
Okay.
If I do anything different in the invoice, so he's up to par and everything's going on. So
okay,
he knew every step of the way.
got it. Okay. Now, at what point let's talk about the parts situation. You had completed stripping the vehicle, right?
Correct.
And you determined that you needed parts.
Yeah, correct.
Please tell the court what happened during this interaction.
Well, when the car arrived at my shop, we put it inside. We started sanding everything down, taking everything apart, and determining, oh, we need the floor, we need the quarters, and all. What turned out from the outside, when you look at the car, it looks okay until you dig into it, start taking paint off and all the goods, and then you find out you need this part, you need this, and it was inside for a couple months, all torn apart, waiting for him to get these parts he told me he was going to get, and he never got. I think he's just making this up. But at my page, I was waiting, and the stall that the car was in makes 100 hours a week. That's equivalent to about $2,000 a week. That the car was sitting in there for 2 months, doing nothing, collecting dust.
All right, listen to my question carefully.
Yes.
The car was in a bay that earns you on average $2,000 a week.
Correct.
And the reason no work was being performed on the car,
Because the customer.
because Mr. McCann said that he was going to get the parts. Is that correct?
Correct.
All right. Now, here's the question. Had you found parts that you needed for the car?
Yes. I looked them up and found them all, everything I needed.
Wait, say that part one more time.
I found everything I needed and sent him everything we needed, and the parts were available.
Okay.
And we could get working, but they were too much. So I waited patiently for months for him to get parts. But they said they never came to fruition.
Okay, so let me just make sure I understand correctly. Once you got to a point where you knew you needed parts, you sent Mr. McCann a list of all the parts that were needed.
Yes.
You sent a list of what those were going to cost, correct?
Yes.
And you let him know that the parts were available.
No. But they were. I never let him know in writing.
You didn't let him know in writing the parts were available, but you're testifying the parts were available.
Yeah, I'm just going to put this out there. He said The plaintiff said that he can't find parts for a cutlass. Come on. Come on. Yes, you can. You just, there's enough of them.
Yes.
And
That's what the cost was.
And were you again insisting that he abide by the contract and pay the deposit so you could get the parts?
Well, that's why I need the money so I can get parts. I don't mess around with customers trying to find parts cheaper because I know what happens. When I get the $5 cheaper. Wait 6 months. Oh no. Give me the money and I'll get everything I need to keep working in the car.
In fact, isn't that what your contract states?
Yes, it does. That's why it states that.
Your contract is for parts and labor.
Right, correct.
There's nothing in the contract that says that
60 something. I can't remember.
work.
Now, it actually states that the client stops me from working for any reason, then the car goes outside.
And the storage fees, right? That's in the
And
contract.
they apply. And the car's been sitting outside for over 2 years now. And I can't control Mother Nature. Winds decides to blow and rain.
Well, you let Mr. McCann know that you were going to have to put it outside because he had stopped
correct.
work.
Yeah, correct. It was inside for 2 months. I'll strip down. I said, if this goes outside, it's gonna get messed up. Oh, I don't care. I can afford the storage fees when I knew you could, but that's
Okay,
It's just-
so what you just said just now is, he said to move it outside, he couldn't afford the $100 a week storage fees?
he knew exactly what's going on every step of the way, Chris.
Okay, but this is for the court to hear. You just testified and you changed the tone of your voice. And I just want to be clear. Were you saying that that's what Mr. McCann said, is that he couldn't afford the $100 to keep it inside and he told you to move it outside?
Well, that's when the parts didn't show up. Then it was going outside.
How many times did Mr. McCann continue to tell you the parts are, I'm getting the parts, I'm getting the parts, I'm getting the parts?
Half dozen.
All right. So at least 6 times he told you he was getting the parts and the car was just sitting
Yeah, correct. Inside.
inside.
All straight down, red go.
All right. And then when it became clear by I think about October, he wasn't going to get the parts.
Then I went outside. After pleading, I need these parts to keep working. I don't want to do this. Don't want to push the car outside.
You told him
It's
you
nothing.
didn't want to push
Crickets.
the car outside.
Crickets.
All right. And so
I can't get the parts. Supply chain. So, well, no, sorry. I can. I don't.
and were you still providing invoices to Mr. McCann?
Yes, the invoice they change daily because stores you could charge daily. And today, I don't know, was it June 22? Was a beginning day when you drive the car. That's when storage fees commence, when according to the contract. When it's because of the client, not because of me. If he would have abided by that, and I couldn't get parts, but I can't charge myself storage. But
Understood.
since that didn't happen, storage applies.
That's why your contract says if it's
Correct.
held because of the client, that's when the storage fees come. You can't get the parts, right?
That's why I need that deposit so I can deal with this. So I get the parts quick.
All right. Before those storage fees ever became exorbitant,
Yes.
was Mr. McCann, did he receive an invoice showing storage fees?
Every day. I don't know, once a week at least.
How do clients get invoices? Your wife emailed them to them?
I email her or me email them. I get all on my computer itself. Goes by the day. And I've been working the car for 30 some years in storage fees. For when the car's on your property, that's the average. $35 to $50 a day outside. And inside it's 100 to 150 a day.
That's the industry standard on storage fees.
Yes, for
Yeah.
body shops across the nation. Because I worked on West Coast, Midwest. It's storage is our thing for a body shop, not for
Oh, no, it's for
one
body
time.
shops, tow lots, even in impound, yes?
Yes,
There's no such thing as free parking, is there?
right. I pay rent for parking lot too,
Sure.
and that's why
How many parking spots do you have on your property?
I don't 15.
All right. And so tell the court how many different ways was Mr. McCann put on notice of the amount of the storage fees? Your contract mentions it, right?
Yeah, I text them an invoice, and the invoice prints everything, and it updates that one line there, their storage fees. It's updated daily.
Okay, so the
But
invoice
everything's-
contains it. Every invoice that goes weekly mentions storage. So before this ever became a big figure,
Yep.
and is that something that Mr. McCann could have avoided by
Yes,
simply
for sure.
paying the first invoice and getting his car if he didn't?
Sure. Yeah. Things were a lot different.
All right. Do you disagree with his contention that he paid his invoice in full?
They paid me for work I did, not the contract, the invoice.
Gotcha. All right, and the amount that you're owed currently to date in work and storage fees, not including attorney's fees or any interest, is that the number 33,749.98, or is the number different?
I don't know what exactly the date, but that sounds pretty close. Had the storage fees and read my eyes or
Yeah. Do you disagree with
no, sir.
33,749.96?
That's correct. But that invoice, it's just various on the date.
And again, this print at the bottom, is this print about storage fees appear on every one of your invoices?
Yes.
And does it appear on every one of your invoices about that you insist on the $10,000 deposit?
Pretty sure, yes.
Right there.
Yes, it does.
All right. So not only is it in the contract, it's in every single invoice. Is that correct? All right.
Yes.
And again, as far as when the car got moved outside, Mr. McCann came there the day the car got moved outside and put a cover on it.
I don't know, day or a couple days. I don't know.
Before any damage was,
Right.
before the car sustained any damage,
And yes.
he came and put a cover on it.
Yes.
And did he, after that point, did he come back routinely? Did he come back weekly, monthly? Did he come back at all and check on his vehicle?
I don't believe so, no. He never came inside. If it did, drive through the park light. I don't know.
Is there anything about your lot that would have prevented Mr. McCann from coming there whenever he wanted
No.
I haven't even got the whole question out, but I think you probably know where I'm going.
No.
Is there anything that would prevent Mr. McCann from coming by daily if he wanted to make sure that the cover was secure on that vehicle?
Nope.
Nothing at all.
Nope.
Is there any, did you boot the car or anything? Is there anything preventing it even from him taking the car?
No, it's it. I think it's like 4 flats now. Because it's sat for 2 years.
But I mean, if he could have come and towed the car off.
Yeah. Once space storage fees, he could take it.
Yeah.
I don't want to.
But I'm saying you didn't chain it to a wall.
No.
So if Mr. McCann contended that he was paid in full, obviously you would have sued him for the storage fees. But what I'm saying is, was there anything preventing Mr. McCann from actually retrieving the vehicle from your lot? Was it tied to a tree? Was it chained down? Was it booted? Was there anything like that?
No.
All right. No further questions.
All right, Mr. McCann, this is your time for cross-examination. Obviously, I know that tensions can be high between parties. And that's what makes this court so much fun. All I ask is just for civility and not to talk over each other as much as possible during this time. If I have to step in, I will. I prefer not to, but just whatever you need to ask of him during this time.
I rest, Your Honor. I've stated my case.
All right, thank you, Mr. McCown.
Killing man.
Callanan.
Okay, that stank. I wanted to hear it. I wanted them to talk.
All right. Close.
Your Honor, as Mr. McCann cited to me during questioning, this is Contracts 101 stuff. He is correct. This is Contracts 101 stuff. Mr. McCann, Mr. McCant, I'm sorry, McCant. To the extent that I've mispronounced that today, I apologize. Mr. McCant and Mr. Cullinan has two adults at arm's length, had an arm's length transaction and entered into a binding contract. There's been no evidence that the contract is void for any reason. And so we've got a contract, and the contract, the language is very clear. And if the court reviews it, as I mentioned during my opening, it states that restoring cars can be a difficult thing to. It's not like when you take your 2022 car in and they know based on changing the oil of that same car 100 times a week, they kind of know exactly what you're going to pay unless they encounter something that's out of the ordinary. But with cars, as Mr. Callanan testified, that are from 1969, as soon as you start removing things, you uncover rust and things of that nature. And so the contract is very, very clear about that. Mr. Callanan doesn't want to deceive any of his customers into that and give them any false hope about the fact that restoring a car is expensive. And so the evidence before the court is that these parties executed a contract. Now, Mr. McCant's testimony, which was contradicted by his own evidence, was that there was a mutual departure from the contract where it states that a $10,000 deposit was paid. But then in his text messages, you'll see he says, at first I thought it was what you were doing is absurd, and he unilaterally changed it, and he decided that he was going to try to run this restoration his way, not the way that the contract stated, which was he was going to make Mr. Callanan prove by weekly invoices that he was doing the work on the car and he was going to pay him progress payments. That's not how the contract worked. That was a violation of the contract. That was a breach of the contract. And in fact, you can see from the timing of his first payment and his own timeline as to when work began, he was already in breach of the contract. And as Mr. Callanan testified, he said, I'm not putting the epoxy on the hood because I'm not buying parts. I'm not coming out of my pocket to repair your car, right? When you haven't even paid the deposits yet. So there was a disagreement early. There was a breach very early on. Now, what my client continued to try to do is make Mr. McCant happy. But that was not a waiver of his insistence on his invoice. If it were, he wouldn't have put it on his invoice. And as the evidence was presented to Your Honor, the $10,000 deposit was on the invoice and he sent weekly invoices. Now, also, as far as the storage fees are concerned, parties are free to contract to whatever, although the statute will provide that people can charge storage fees. That's if there's no contract between the parties. There's statutes are out there for when people don't have contracts.
Of course you are. That's awesome. That's
In
so
this
good.
particular case, there was a meeting of the minds as to that there would be storage fees charged. The amounts of the fees were present. They were posted in the shop. They were discussed over text, and they were present in the invoices. So his invoice, before he ever incurred the first storage fee, the very first invoice that he got on July 1st that he paid, talks about storage fee. Before he ever had to pay or before he was ever charged a storage fee, it stated right there in the invoice exactly what the storage fees were. Those storage fees could have been and should have been avoided by Mr. McCann. But what he did was, when my client hit a point where he needed parts, he said, as he testified to, I let him know, this is what your car needs. This is what's going to cost. I need the deposit. To which Mr. McCann said, stop the work. Stop the work. That's and so at that point, my client is under the contract, is entitled to charge those storage fees. It's plainly in the contract. Now, Mr. McCann actually testifies that he deals with contracts all the time. All the time. So the fact that he can't claim ignorance of the terms of this contract where it says if you stop work, as he did, you're going to be charged storage fees. That's exactly what happened in the case. This case is very straightforward. If you stop his work, you don't order parts, you're going to pay storage. He's 54 years old, I believe. And as Mr. Callanan testified, it's industry standard, industry-wide, that you're going to pay storage fees. His are on par. His are actually less than the average. I think the average is about $58 a day, but my argument isn't evidence, obviously. But there was a breach of the contract. Mr. McCann was presented with invoices. Well, first of all, it was supposed to be that he paid the deposit and then that deposit was billed against with these invoices, but that didn't happen. So he was presented with weekly invoices instead of the contract said he would only get monthly invoices. So right off the get-go, this man is trying to accommodate this man by doing something he doesn't normally do, which is to invoice weekly at his request, trying to make him happy. But it didn't make him happy. He let the car sit, and as the evidence showed, before the car ever went outside and sustained any damage, he let him know, the car's been sitting for over a month. It's costing me. It's got to go outside. You're going to incur storage fees, $100 a day, or I'm going to have to roll it outside. That conversation obviously happened because the next thing that happened was the car got rolled outside and Mr. McCann appeared and covered the car and secured the car. And as my client testified, it's not in a gated, fenced or whatever. And as was testified by Mr. McCann, he said during his testimony, I could have just taken the car. He felt like he was paid up to that point. He could have just taken his car, but he elected to let it sit there and accrue these fees that he was already on notice of. I don't know what his expectation was at that point, but that was before he incurred exorbitant fees. Again, the onus here is on Mr. McCann, not on Mr. Callanan. And as Contracts 101, the breaching
You're
party
so nice to
is not
us.
entitled to relief. Mr. McCann was the breaching party. He is not entitled to relief here today. He breached the contract. My client incurred damages.
Hi, Crystal.
And those the court has evidence of those damages, both by the invoice as well as the testimony of my client. And I would ask the court then to deny Mr. McCann's petition for $6,000 of damages incurred from the car sitting outside, as well as, and I would submit that 13,611 attorney's fees would apply in this case based on bad faith But and I can brief that issue for the court, but I'll be candid with the court. Mr. Callanan is going to, he and I have a contract for services, and I'm going to let him work that off on my old car. So, and the contract, the retainer in the case, according to our contract, was $2,500. Is that right? Oh, no. Sorry, my bad. I forgot about inflation. $5,000 retainer, Your Honor. And what I'll do is I will submit an invoice. He may not have used all that $5,000. So I'll submit an invoice to the court before the court, if the court rules on the issue of attorney's fees, I'll submit the invoice. But at this time, if I would make myself available to Mr. McCant to ask about my years of service and the amount that I charge, which is $3.25 an hour, which is consistent. I will state in my place, consistent with other attorneys with my years of experience and practice in this
Hi,
area.
Spud. We're in
It's
Georgia.
Trial litigation. Any questions for me? Oh, okay. Thank you.
All right, Mr. McCann,
Yes.
this is your time to make a very similar argument as Mr.
I'll be very brief, Your Honor. Very brief. I entered into agreement with Mr. Cullen, if I'm sorry if I'm mispronouncing your name, and Redemption's Body Shop on June 27, 2022 to perform work on my car. In regards to the contract, it had a mention of storage fees, but the fees were not outlined. As I stated in the very beginning, contract law 101, if it's not in the contract, it's not enforceable. Bottom line with that. In regards to the storage fees, State of Georgia statute, Georgia Code 44-14-363 in 2022 states that all mechanics of every sort shall have a special lien on personal property for work done and materials furnished in manufacturing or repairing the personal property, and for storage of the personal property after its manufacture or repair, which storage begins accruing after 30 days. Written notice to the owner, key word, written notice to the owner of that fact, storage is accruing, and of the daily dollar amount thereof, and said in 2022 states that all mechanics of every sort shall have a special lien on personal property for work done and materials furnished in manufacturing or repairing the personal property, and for storage of the personal property after its manufacture or repair, which storage begins accruing after 30 days. Written notice to the owner, key word, written notice to the owner of that fact, storage is accruing, and of the daily dollar amount thereof, and said notice shall be mailed to the owner by certified mail or statutory overnight delivery addressed to the owner at his last known address. No official notice was ever sent to me. Okay. The second part of that, Georgia Code 44-14-363, 2002 also states in paragraph B, the maximum amount of storage that may be charged be $1 per day. Nothing contained in this code section shall allow a fee for storage to be charged on any item with a fair market value in excess of $200. Storage charges pursuant to this code section shall not apply to motor vehicles now hereby by Chapter 3, which we're talking about a motor vehicle, of Title 40, nor shall the storage fee be charged if there is a bona fide dispute between the customer and the mechanic as to the manner of the repair or the charges for repair. This is Georgia Code.
The judge is going to tell him the law.
This is Georgia Code, which everybody has a copy of right here. So that's in regards to the storage fees there. So now, as I mentioned, I have the same identical car being restored at a body shop in Dalton, Georgia. I have a contract with that person. It doesn't mention anything about storage fees. It doesn't mention anything about anything outside of just the repair to the car. When I dropped that car off with that body shop, the gentleman asked me for $5,000 up front, which I felt was reasonable. He's now done about $15,000 worth of work. He's invoiced me monthly for the repairs and parts. I've paid him monthly for the last year to restore that car, and there's been no conflict. I am due to pick that car up in a month. He's just putting finishing touches on it. It's painted and everything. We've never had one dispute. Same identical car, two different body shops. One body shop, an issue. The other body shop, a non-issue. And then the last point, and I'll close. As I mentioned, the car sat outside for 8 months after I personally covered it up and strapped the covers down. The negligence part on Redemption's body shop is the minute that they noticed that car cover was off the car, give the customer a courtesy call and say, I noticed your car cover blew off. You may want to come address it. That never happened. 8 months passed. 8 months passed. And the only reason that I found out that the car was exposed to the elements is because he told me in a text. And I come up and the car has been completely rusted out because it's been outside without doors on it that he removed. He put all the other people, he put the fenders back on. He didn't fix the quarter panel. He didn't put the doors back on the car. So a convertible sitting outside in the weather for 8 months is going to be damaged. So now the car may not be salvageable.
You are right.
So my claim is for $6,000, but the value of my car at the time that I took it to him was about $20,000. So I'm possibly out of $20,000 or more. The car that I have restored down in Dalton, Georgia, I just had it appraised at $45,000, fully restored. So I'm going to take a loss or a hit on this any way you look at it. So my claim is for $6,000. I'm not asking for anything else. I want my.
Nope, I paused it because I want to give David props. Come on, there we go. No, Sarah. He didn't read that part because no one said that part yet. But the judge is going to. But David already told us. David spilled the beans. It excludes motor vehicles.
Car back without paying any storage fees because of the damage and because of the negligence and everything. And we can close this case. I rest.
Hello.
Based on the testimony that was given today, I do find in favor of the defendant in this case. Rationale behind it. It seems that there was conflicting testimony as to this waiver portion. If there was more to the waiver portion that I could have tied on to, I would have found it. And I just did not find that to be able to waive that particular portion of it.
Hello.
Now, that being said, with regard to damages, that's where my next step goes. Obviously, the invoice is at $33,749.96. It's uncontroverted between the parties that $3,375.96 has been paid by the plaintiff already. The $10,000 that was added on to that invoice was for deposit for work. So I'm subtracting from the invoice amount the $10,000 for the deposit, as well as what has been paid by plaintiff. That comes out to $20,374. I don't feel that I have enough evidence on the damages of the rust from the storage. However, I do think that there was possibly some steps that Mr. Callanan could have taken to mitigate any damages to the vehicle. So what I'm going to do is I'm going to call the attorney's fees and the mitigation of damages, the $6,000 versus the $5,000. I'm going to call that a wash. So the total amount of award is $20,374. Before, the one last thing that I will say is when it comes to the amount of storage fees, Mr. McCant, you are extremely bright and extremely knowledgeable, and you were so close. I don't mean that to be funny. I really am trying to give you some good praise here. The one problem with the code sections that you cited is that there's a not. That one word takes the motor vehicles completely out of applicability to that statute. So that dollar amount per day is not applicable to motor vehicles.
David, you're
Had it
so
been anything
smart.
other than a motor vehicle, you would have won that particular issue, and I would have reduced the storage fees down. Okay. So another context in magistrate court that I deal with on a daily basis is a action called an abandoned motor vehicle, and that law has some ideas as to what storage fees can and can't be for vehicles specifically. They put it towards the Department of Public Safety, and this is for non-consensual towings and things like that, and that kind of paints a picture of what the state thinks is appropriate for the storage of a vehicle that has been towed in a non-consensual basis. And according to them, their daily storage fees average around $39 a day. It depends upon the weight of the vehicle, but 33, there's a 39, there's a 52. It goes all the way up to $98 for something that's well over 20,000 pounds, which I know we're not dealing with as a cutlass. We're not dealing with that here in this particular case, but that gives you kind of a range for non-consensual towings to just an outside lot. Okay. There's other things related to electric vehicles and things like that. So I feel confident that the storage fees are more likely than not below market for what the situation is at this particular time. So the judgment will be the $20,374. Now, that being said, Mr. McCant, you obviously do have the right to appeal this decision to Superior Court, which is the court above me. Okay? They have the ability to review any sort of decision that I make. There's a whole separate process that goes through that. Specifically, my best advice that I can give you is to go down to the clerk of court's office on the first floor. They have a pamphlet they can give you on what's called a petition for review, and kind of goes over what the process is. And you have, I believe it's 30 days to file that petition in this particular case. Okay. And that's for if you feel like I've abused my discretion in any way, or you feel like I just got the law wrong, or I didn't hear all the facts correctly, whatever it is. Now, that being said, it being Superior Court, there's a whole lot of other things that go along with that.
Hello from PA.
I don't have to
Hi,
tell you, like I
Pammy.
said, you're a very intelligent individual. Superior Court is a lot more backed up than we are. Attorneys are more likely going to be required in Superior Court as compared to Magistrate Court. So there are certain downsides, but that option is still available to you. Okay. And the majority of the time, it is basically a brand new trial in Superior Court. So basically, my stuff gets put on hold and then it goes for a new trial. However, Mr. Conwell knows this. I try really, really hard to listen as much as I can during these trials and hearings, and to give you as much of a insight as to what I'm seeing in the facts and the law as to why I decided what I did. My order doesn't reflect it. It's very bare bones, but my dicta to you in a hearing tells you pretty much exactly where I am on things and why I decided what I did. Now, like I said, you have the ability to disagree with that all that you want, and you can, again, for sure, take that up to another judge if you feel like you need to. But that is my honest opinion of the case as it stands upon Georgia law. Okay. I have signed the order for the judgment, and Ms. Cranwood will get copies to everybody, assuming there's nothing else between the parties. Once you receive copies.
Hi, Birdie.
Thank you.
Thank you, Your Honor.
Toinette, you could remove the guard? No.
This does conclude my business. May I be excused?
You sure, may, Mr. Conwell?
Thank you, sir.
Thank you. Mr. Callahan, do you happen to know Gary Dishroom?
I'm here. You can't see me because my camera just stopped working. That's okay. That's fine. Welcome, new people who just came. I'm from PA too. Pammy's from PA. Amanda's from PA. I'm from PA. Lancaster, not Lancaster. Hi, Trisha. Yeah, he left quick, didn't he? He walked out of that courtroom like it was on fire. You can You can see me? Am I picking my nose right now? So that was the Father's Day one. It had tools, it had cutlasses, it had lawsuits. It did not have any tasing, which, it just happens. I have a cutlass too, David. Not really, I have a cut loss. I got it from Temu. No, I didn't. But I do know the parts for cutlasses are out there. They're not hard to get. I like this judge. I mean, I like the judge. I see him a lot. Not a lot of crazy goes on in his courtroom, so I don't get to play him a lot. But Pennsylvania or Michigan, yep. Yeah. I think the most, I'm going to look real quick and pray that my computer doesn't just break. I think most of my viewers are from New York, though. Isn't that crazy? Nobody in here says they're from New York that I know of. I'm going to look. I'm going to look right now. It just takes a second. Analytics. Audience. Oh, man. Yeah. Cities. Oh, Chicago jumped up. Oh my gosh. And Dallas jumped up. So it used to be New York. Chicago is number one. Most of my viewers are Chicago, and then Dallas, Texas, and then New York, and then Seattle, and then Houston, and Los Angeles, Atlanta, Phoenix, Philly. Yeah, Philly in the house. Vegas, and then Sydney. 219 from Sydney, Australia. That warms the cockles of my heart. And then down a little bit further is Melbourne, which I'm going to get in trouble for saying wrong, but it's Melbourne, 170. And then Brisbane is 152. Oh, guys, we got 142 from London. Bloody hell, they need to start typing in accents in the chat. Bloody hell. Florida, Sacramento, Canada, Perth, Australia is definitely in the house. Canada. Down at the bottom of the list that I have that I see is Miami. And right above that is Mobile, Alabama. I know I said that wrong. I know that we have Scotland, but it wasn't on my list. No, Erie is not great in the winter because the way the air comes right down from Alaska, and then it goes over the Great Lakes and Erie, man. Mobile is down there too. So we can't say Melbourne anymore. We got to say Melbourne. Yeah, I did that with my car, Sarah. I changed my car GPS when we used to have car GPSs to Australian, a male Australian accent. And it was the greatest thing I've ever done for myself in my entire life. I loved it. I just loved when he spoke to me that I would put my GPS on all the time. When I was going to work, when I was going home, I knew where to go. I just wanted him to talk to me. I loved it. I got to go get me one of those old GPSs in the car. And The one I turned to German once by accident, because it was in German, I couldn't fix it because I didn't know how to speak German. So I had it was oh God, what were they called? Not Tim Tam, because that's not it. It was those GPSs. I think it's like a 3-letter word or 2 3-letter words. Stupid GPSs were called. Tom Tam. Tom. Thank you guys. I knew if I waited just a second. I'm gonna go find an old Tom and change it to Australian and drive around. I'm just gonna drive around all day. Thank you. Listen, I don't know if you guys have been keeping track, but I have. It has been a hot minute since we've had a Karen in court. So I feel today is the day. I'm so excited about courts today. I don't know what courts I'm going to get. I don't know which judges I'm going to get, but I feel like we have a Karen any day now because it's been a while since we had a Karen. So I'm just excited. I was thinking maybe next month to do like specific days. So I'm going to do a Colorado day, all Colorado courts, a New Jersey day, a Wisconsin day. I'm not going to do Michigan. You guys see enough of Michigan. Georgia. I can do a Georgia day. I can do a California day. I can't do a New York day because New York doesn't have live streaming. But I can do a Jersey. That's the best I can do for you New Yorkers. I really don't think I can do an Australian day because, guys, getting court cases in Australia is just damn hard. It's just damn hard. I could try to do a Wisconsin day, but that means that would be hard. That would be really hard, but I could try it. Nobody else can possibly do a Wisconsin day. The only Wisconsin judge I know on YouTube is, I love her. Oh God, she knows the law so well. And it's from Burnett County. Can't remember her name. She's so good though. I've seen her body slam lawyers with her law talk. She's like, oh, is that the law? No, this is the law. Blah, 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 blah. Lawyers run away crying. I know. Some states just don't allow it. I can't get Pennsylvania. Although they say that you can, you can't. Trust me. If you could, I would have. Actually, that's, you know what? I think that's not true. I just found a way the other day. It's how I got that, Oregon. I got a streaming case in Oregon in a way that I wasn't supposed to. Not illegal or anything, but I bet there's some PAs I could do like that too, but I'm really nervous to do that. I don't want to get in trouble. I'm looking, Crystal. I'm looking. I might just do it. The cute blonde judge. Yes, legal. I just love her. I love when she body slams lawyers. I just love it. It just makes me smile. She does sound fun. I can't do an Upper Michigan day because everybody covers Michigan. I'll just be replaying the same dang cases that you can go see on every other channel. Look at this case. This case you can't find on any other channel. No other channel had this case on. None. Zero. Zip. Nada. Because you have to actually, you have to try to get this case. I know. I can't wait till I get my computer back. Darkest night. Thank you so much for the computer fund. Seriously, that was way more expensive than I thought it was going to be. Tinsel's in Perth. At least I can say Perth right, Carolyn? Perth? Perth. Okay, I can do a Hawaii court day easy legal. I can do a Hawaii court day. I have tons of cases from Hawaii. However, none of them have any verdicts, and it's all Supreme Court. So it's boring. I mean, boring with no end. It's like marital sex. That's what it's like watching a Hawaii case. I don't know where to find DeSanto. I haven't looked for her. Fine. Canberra. I'm thinking. I think no, the lawyers just don't. They wear suits, which is stupid. They should wear their little Donnybrook. Canberra. Yo, bra. Miss Fields. Kelly, go to Miss Fields for DeSanto. You know, you people from Australia say I'm pronouncing your stuff wrong, which I am, but you can't say the city that I live in. You would say Lancaster, and it's just not. I don't know. I would play every single day if I could. Totally. That judge is amazing. But I mean, every time I look at one of his streams, he has like 4,000 views. So somebody has to be covering him. He's so good. He's just so good. I don't even know if I've ever seen him because like I just see the lawyers' tables and I never see the judge. I want to know, okay, we had China in here, travel. Lancaster. It's just Lancaster. I know. Everybody should have a judge crush on McBurney. He's great. I mean, he's really, really good. And he gets some good cases. He doesn't get DUIs and domestic violence. No. He gets some good cases. We should all go watch McBurney someday. It's on YouTube, so everybody can. Detroit. Yeah, Crystal. I know when someone from York, guys, York is right beside me. I can throw a rock at it, not really. I can tell when someone from York comes to Lancaster because they say Lancaster. Not really. They don't say it in a southern accent like that. It's just long and drawn out and not right. It is KC. Maybe I'll get some McBurney. I don't know. I really strongly dislike playing anything anybody else might play. I just don't like it because you guys already see that. And when I tell you I have thousands and thousands and thousands of other courts, I literally have thousands and thousands and thousands of other courts that nobody sees every day. So I don't need to play the courts that are on YouTube. Maybe on the weekend because the courts that I have are all live. All of them. Every single one of them are live. So if I don't get it as it's going on, I'll never get it. I can't rewind. I can't do anything. So during the weekend, if I didn't record enough content during the week to cover the weekend, then I go to YouTube and I grab some of that. But even then I try to do judges no one else really does. All right, fine. I love McBurney. I love him. I'm gonna get some McBurney. All right, here's what I'll do McBurney on the weekends when my lives are just not on. Yep. Pennsylvania, Dutch County, Lancaster, Amish. You get paid to drive around Australia, but everything tries to kill you in Australia. Just kidding. I'm just kidding. I'm just kidding, Rebecca. Rebecca said something the other day in Discord. So if you guys don't know, sometimes I go into Discord after a stream, like I'm probably going to today, and I go into the voice channel if anybody wants to chat. So Rebecca comes in, she's from Australia. We're like, yeah, in America, we think everything's trying to kill you in Australia. Well, then she said something that got me good, and she doesn't even know. Okay, so she's like, not everything is trying to kill you. She says there's just certain things that we do that we always do, and we're fine. And then she said, like, we shake out our shoes before we put them on. Ever since she said that, I have been shaking out my shoes because I keep thinking there's a spider in my shoes now. So I would be fine if I went to Australia because I already shake out my shoes now. I don't want a spider to get me. Yeah, you're right, Legal. They're all trying to kill you. Some just try to maim you. You're right. I forgot to tell everybody, I don't have any more courts. I don't have any more videos today. So you guys, if you're just here for the video, you probably already left. But if you're hanging on waiting, maybe there's one more, there's not. But I am going to Discord today. After I feed these animals, I'm going to Discord. And I'm going to pop down into the voice channel. And if anybody wants to talk, they can. If you don't have to. I'll go to bed. I do have a doctor's appointment this morning, so I can't stay late. No, I never shook my shoes before, but I do now. Bye, Darkest. All right, guys, I'm going to pop off of this live. This live is good enough. And I'm going to go on to Discord as soon as I feed my animals. I will see you in Discord soon. Come to Discord. The link is in my YouTube page description. Come to Discord. I'm going to go shake out my shoes, feed the animals, and go into Discord. Bye, guys. Be good. Thanks for coming out. Thank you, thank you, thank you.